So in this podcast, we're going to examine both the powers and duties of a receiver, how receivership ends, and also how receivership interacts with other procedures. So let's start by looking at the general powers of a receiver. A receiver will have the general powers stated in the appointment documents or the court order if you have a court-appointed receiver. The Corporations Act, interestingly, also extends these powers in section 420, so you need to go and have a look at that section. You'll see that under subsection 1, a receiver is given a general power to do all things necessary or convenient for or in connection with the attainment of the objectives for which they were appointed. So a very wide power which allows the receiver to do a lot to fulfill their function. But if that isn't enough, subsection 2 goes on to say that subject to the instrument of appointment or the court order, if you have a court-appointed receiver, that receivers have a long list of powers. These powers are for receivers only, not for controllers generally. So go and have a look at subsection 2. It includes powers like to lease or dispose of property of a corporation, to engage or discharge employees, to enter into possession and take control of property of a corporation in accordance with terms of the instrument, to execute documents, etc. It even includes to bring or defend legal proceedings on behalf of the company. So there are a large range of powers that cover lots of things that a receiver might want to do to gain the funds for the secured lender that they're acting for. So all of these powers are in section 420 subsection 2 of the Corporations Act, and they will apply unless the appointment document specifically excludes them or restricts the receiver in some way. Now, in addition to these powers, the receiver can require reports from all sorts of people. For example, from officers, as we know the definition is in section 9, even past officers of the company, to really tell the receiver what's happened, chase things up that may have disappeared. So, for example, if directors have tried to hide assets from the lender, this will enable them to chase those assets. Under section 431, the receiver has the power to inspect the books and records of the company. Remember, the receiver is coming in from outside, so this will be a necessary task. Normally, one of the assets over which a security will extend will actually be the books of the company. If for some reason the documents don't include security over the books, then this is still a power that's provided for in section 431 of the Corporations Act. The practical problem can be that not every company will actually keep accurate books and records of their activities, and that's what happened in the case of Re-Jet on your PowerPoint. So section 424 provides that, as with a lot of these situations with administrators and liquidators, it is possible for a receiver, if they're unsure about the actions to take, to apply to the court for directions. I have already mentioned section 418 capital A regarding the ability to obtain a court declaration as to the validity of their appointment as a receiver. So I mentioned that in the last podcast. Now, receivers also have the power to sell property that is secured by the lender's charge. But sometimes some assets might in fact be subject to a prior charge, so another security interest or interests. If that security interest predates the receiver's lender's interests, then the earlier security interest will have priority provided that it is properly registered. And we learnt that when we looked at securities and priorities, but just note, remember we talked about PIMSs in that context as well. So usually the earliest in time, the earliest security interest in time will have priority if registered properly. It could be that the earliest security interest holder will in fact say we don't want to sell that asset at all. For example, the market may be forecast to improve in the future, so they want to delay its sale. In this case, the receiver can go to court under section 420 capital B and get the permission of the court to sell that asset despite the earlier security interest. The other thing to keep in mind is that, as mentioned last week, there can be under the PPSA purchase money security interests. And even though they might be registered and perfected after the security interest that the receiver has been appointed to look after, we know they have super priority, don't they, under the PPSA. Therefore, they're entitled to take their property under their PIMSy and deal with it. So, for example, to sell it to gain the amount that they're owed. If it's a lease, to take the property and deal with it. So the thing about properly registered purchase money security interests, so PIMSs, you will recall, is that they won't be available to the receiver because they won't be regarded as property of the company under section 51 capital F subsection 2 of the Corporations Act. So the receiver won't be able to take that property, but remember, they must be properly registered on the PPSR. So receivers have duties. What do they have to do? They have to act in accordance with their appointment, so they have to deal with the property of the company in order to fulfill the obligation that they have under the lending agreement. This will, of course, normally be to repay the loan. Their primary duty is to the secured creditor/lender who appointed them. Now, authority for this is the Expo International case on your PowerPoint. Even though there is this primary duty, there is still nevertheless remaining duties to the borrowing company. Remember the definition of officer in section 9 of the Corporations Act also includes a receiver. So they still owe common law and statutory duties, don't they? At common law, these duties extend to exercising powers in good faith, acting within the terms of their appointment, accounting to the borrowing company after the lender's security has been discharged. So if the company owes, say, $100 to the secured lender and the receiver goes in and sells that asset for $120, then the receiver must, of course, account for the remaining $20 back to the borrowing company. So their primary duty is to the lender who appointed them, but there are remaining duties back to the company, and one of them is to account once the lender's security has been discharged. It could be that the company may only owe the lender $100, but the receiver sells the security and they only recover, say, $80. So there's nothing left for the borrowing company. So those are the duties at common law. Generally speaking, there was a lot of dissatisfaction with these duties, and in the 1990 amendments, what they call the Corporate Law Reform Act, that act brought in the specific duty under section 420 capital A. So section 420 capital A places an obligation on the receiver to take all reasonable steps to ensure that they sell assets for not less than market value, or if there is no market value, the best price reasonably obtainable. Now this makes sense because when you think about it, the incentive for the receiver who is appointed by the lender is to just get the lender their money back under the defaulted loan agreement. So this statutory duty ensures that the borrowing company's interests are also considered. And we know that companies have shareholders and other creditors, so this protects their interests. This statutory duty ensures that the company's interests are considered, and it takes away the temptation for a receiver to just sell the asset for the amount owed to the lender. Now, one of the problems with Section 420 capital A is that it talks about not less than market value, or if there's no market value, the best price obtainable. While it isn't entirely clear what is meant by market value or best price from an economic perspective, the courts have really grappled with this and juggled this. There is the case on your PowerPoint, Giola and ANZ. So this case was interesting because it involved a property in northern New South Wales, which was owned by the family of poet Judith Wright. Now this property had been in the family for 120 years, and over that time they'd bred cattle or sheep under a restricted breeding regime. I'm not sure, I can't remember if off the top of my head if it was cattle or sheep, but had bred animals under a restricted breeding regime. Now, they were very valuable breeding animals. The receiver came in and said, well, we have a piece of real property here with breeding cattle on it, or breeding animals on it. They appointed an agent who said, we'll sell these animals to the abattoir and the property as vacant. We'll sell that as vacant property. The directors of the company were upset because they sold the cattle, so the receiver sold the cattle or animals as ordinary abattoir animals, when in fact they were very valuable as breeding animals. They complained that the receiver had breached their duty by not obtaining the market value, or if there was no market value, the best price reasonably obtainable for the animals. The court held that the receiver had breached his duty. The directors had even contacted the receiver and told him to sell the animals for a special price because they had that special value as breeding animals, and he didn't do anything about this. The court said that he'd misidentified the market. He'd sold them in the wrong market as normal abattoir animals rather than special breeding animals. So the correct market to sell them in was the breeding stock market. In the Court of Appeal, the court said, when we are talking about market value, we're talking about something that has a specific price. So for example, a share on the stock exchange. Everyone knows what the price is and it can be identified. Some things won't have a market value. So for example, a rare piece of artwork. So you don't really know how much it is worth because there's nothing that you can judge the price by. So in this case, the receiver needed to obtain the best price reasonably available. I have put some other cases around this issue and this duty on your PowerPoint. Generally, the receiver is expected to advertise the item in the market where it fits. So for example, if you have breeding animals, then you need to advertise it to people who are interested in breeding animals. Okay. The Floorgale uniforms case on your PowerPoint is also on point here, as is BOS 1. Okay, under Section 420 capital A, you must find out what the market is and what the property is worth. So, for example, as I've just said, if it's a specialised product, you must look for buyers in that market, not just generally. Also, you can't disregard offers or advice from those within the company, so for example, directors. And there's no obligation to wait until a market improves. So a receiver doesn't have that obligation. So even if the market is depressed, there's no obligation to wait until the market improves. However, if you sell that item, the secured property, to a related parties, then it may be scrutinised by the court to ensure that you're getting the best price. Okay. So just a final point, a problem with section 420 capital A is that it doesn't specify any remedy. It says the receiver has a duty, but doesn't then say if the receiver fails to fulfill this duty, the receiver is liable for XYZ. You have to therefore establish damage as a result of the receiver breaching this duty. So for example, the company might suffer damage because they may owe further amounts to other creditors and suffer financial loss as a result of the receiver breaching their duty and selling for a price that's not the best price reasonably available or the market value. Keep in mind that under section 420 capital A, the obligation is to take all reasonable steps to get the market price or best price. So you don't necessarily have to get it or guarantee that you will get it as a receiver. You just need to take all reasonable steps to attempt to do so. Achieving market value or the best price may be impacted by, for example, the types of assets you have, how much debt there is, the circumstances in which the company is being run, what sort of expert advice you can obtain regarding the particular type of asset being sold. So these are all considerations that will impact on achieving market value or the best price. So just keep in mind that section 420 capital A is quite important in terms of the obligations receivers have. There are also a large number of specific statutory duties that apply to receivers. Remember that a receiver comes under the definition of officer in section 9. I've said that before. Therefore, the obligations under section 180 through to 184 will also apply to a receiver. Interestingly, there are almost no cases about trying to enforce these general statutory duties to receivers, but in theory they do apply. Section 420 capital A, I just mentioned that section, tends to be the main one that's most often litigated. Just a note on section 433, the last point on your PowerPoint. Generally speaking, we know that a receiver is there to get money owed to a specific lender or creditor who appoints them. However, section 433 does require in certain circumstances that the receiver pays some other creditors first before they pay the secured creditor that they went in for. So section 433 only applies where the receiver's appointment is under a circulating security interest. So this applies when the receiver is selling circulating assets like inventory, trade debts, cash, etc. The receiver has to keep this money separate from the sale of the fixed assets or non-circulating assets, and out of the money from the circulating assets has to pay certain other creditors who have priority prior to paying any amounts back to the secured creditors out of the funds from those circulating assets. Now have a look at section 433. It lists what those priorities are. The top priority is if the receiver receives an insurance payout from an insurance policy that the company has, that has to be put in place to protect third parties. Then the receiver has to pay that money directly to the third party who was injured. So this makes sense, doesn't it? The classic case, I guess, is if you have a retail store and a customer falls over and injures themselves, and the retailer has an insurance policy which is for the benefit of any insured person, of the injured person, sorry. If a receiver intervenes in between the time of the accident and the payment, and the receiver collects that money from the insurance company, the receiver has to pass it on to the injured person. So they have priority. There is also a priority for certain audit fees where ASIC has ordered an auditor not to retire. The main one under Section 433 is for employees. The receiver is obliged to pay employees for wages, super contributions, leave of absence, etc., that have all accrued prior to the appointment of the receiver, and also for retrenchment payments whenever that comes up in time. So in summary, these things have to be paid in priority out of the funds from the circulating assets. Now, regarding liabilities of a receiver, the general point is that because the receiver gets appointed as agent of the company at common law, the receiver isn't liable for anything that they incur because they're incurring it on behalf of the company. However, the Corporations Act steps in and makes the receiver liable for certain amounts under Section 419 and Section 419 capital A. Under Section 419 subsection 1, the receiver becomes liable for debts that they incur once they've been appointed. So when a receiver comes in and starts to incur debts, those debts become the personal liability of the receiver. The receiver is entitled to claim the money from the company, but if there isn't enough money in the company, then they will become personally liable. So a prudent receiver will protect themselves usually by obtaining an indemnity from their appointer, that is the lender. So examples of these types of debts will be money owing for services or goods that they purchase or property that they hire on behalf of the company during the receivership. Now, there can be problems if the receiver has been appointed invalidly, because then they might have incurred these debts but they won't have a right to indemnity from the company itself. Now, Section 419 subsection 3 does give some potential relief here. The receiver is generally not liable for any contracts entered into before he or she is appointed. So their liability under Section 419 only arises for the new things that they incur post-appointment. So that means that for things like wages for continuing employees, strictly speaking, the receiver will not have personal liability. So if the receiver continues a contract that was already in existence prior to their appointment, they won't incur personal liability for it. The only exception is that Section 419 capital A alters this with respect to leases that the company has. The receiver may be personally liable for lease payments after 7 days if the company continues to use the leased property and fails to give notice of intention to disclaim. So, after their appointment, the receiver has 7 days to decide if the company is going to continue to use the property under the lease. After that 7 days, the receiver then becomes personally liable for the payments under the lease, as if they had entered into the lease themselves. Now, regarding liquidation, generally speaking, there will be some other type of administration that will occur at the same time as receivership. That's quite often the case. Because if you have a receiver appointed over all of the company's assets, the receiver will deal with those assets, which will mean that there won't be much left for anyone else. So it will mean that the company will also go into liquidation or at least voluntary administration. If there is a liquidator appointed, then the receiver's position as agent for the company will cease. We're going to learn later that this is because the liquidator, once appointed, becomes agent for the company. Even though the liquidator might be agent for the company, the receiver still has control of the secured property. They will, upon the liquidator's appointment, change their position. They will cease as agent for the company and become agent for the lender or mortgagee. So their legal position changes, but from a practical perspective, their job continues. It also means that the liquidator has to sit back and wait until the receiver finishes their job and has dealt with the assets and paid off the debts to the secured creditor, and then the liquidator can come in and deal with what's left. Under Section 420 capital C, now if the liquidator wishes, they can allow the receiver to continue to act as agent for the company. Regarding the supervision of receivers, Section 423 allows the court to investigate the behaviour of a receiver. If they have a complaint about a receiver's behaviour, you can, so if you're the one that has the complaint, you can apply to the court to have the receiver investigated. Because they are registered liquidators as well, we know that already, and the registration is done by ASIC, if you can complain to ASIC, and they may investigate that complaint to see if the receiver's done something wrong. If ASIC believes they have, then ASIC may pursue this through the court, Section 423, or they can apply to have the receiver's registration cancelled under the Companies and Liquidators Registration Board. Receivership will obviously end. It's for a limited period of time, either because the debt owed to the lender/creditor has been repaid or everything has been sold off and nothing is left. If it's the later scenario, the receiver will be done. They'll walk away and the company will be deregistered. If a liquidator is appointed, the liquidator will deal with things from that point. A receiver has to always ensure that before they leave, there's enough money to pay the debts that they owe or have incurred under Section 419, and also under Section 433 for any priority payments that we talked about that must be made. Now, as I said earlier, a company in receivership may also be in administration or liquidation, so the remaining assets and the company itself will be dealt with under those procedures, which we're going to talk about in the coming weeks. If the receiver has control of all of the business and its assets, the administrator or liquidator has to wait until the receiver has finished, and then they deal with what remains if there is anything left. That's the end of this podcast. Thank you.